go ahead and get started. I'm scheduled to go from 1 until 2:15. Sometimes I break that and it goes a little bit longer, so I apologize. I hope that it's that little bit of extra time is worthwhile to you, and frankly, I hope the entire thing is worthwhile to you. The recordings, I don't know. We put the recordings online, which is kind of nice, but at the same time, I really prefer to be live. So I think as far as doing these in the classroom environment at the association, we're going to be doing that probably in the next month or two. We'll be live again, but I think that we're also going to tape the event so that people will be able to not have to come into the association. And I think as we've gone on here, the COVID-19 thing has really brought out a lot of changes in our industry. And I think you're going to find changes in what you do as far as working with buyers and sellers and things like that are concerned. So hi, Debbie. Hey, Rhea. Okay, so I'm going to go ahead, already 2 minutes into it here, but we got to go. I mean, we got stuff to do. So I'm going to start us off with our slideshow. So from the very beginning, and I've got my other ear on over here where my other computer is just flying with stuff. So we're going to do that. Live captions and subtitles, show a live voice transcription on the screen as you present. Subtitles can be in your, for crying out loud. Okay, anyway, I have upgraded myself, if you can call it an upgrade, I have upgraded myself to the newest version of Office, and so here you go. So we'll see how this goes. Anyway, PowerPoint to get started with. So we are at the Greater San Diego Association of Realtors. Here's a lot of stuff that I've done. I've always said, and most of you have heard this before, that I think awards and trophies are things are for things that you have done. I'm really more interested in what are you doing today. So what's coming up, and for all of you that are on today, I hope you're the superstar for next year. Having been management at the top 3 largest brokerages in San Diego County, I can tell you that my superstars of last year are not always my superstars of this year. So I'm hoping that you'll be this year's superstar or next year's superstar, as a lot of people are getting out of this business. Interestingly enough, we're anticipating a 20% drop in the numbers of licensees in California. That's a significant number. And so for those of you that are hanging in there and that are learning all these new things, we need you, because we need you to fill that void of what is not going to be going on. There are going to be people that are, the ones that were out there that, are living on the edge are going to be going away. And so guess what? We need you to help us do these transactions. So thank you for being here for that. I'd like to thank the association, first and foremost, thank the association for allowing me this opportunity. We have a great education committee. I really think that you should be as involved as you can be. And as you know, I'm pretty involved. And thank you to Jane. 2 minutes before we got started, Jane is already sending me, has been sending me emails. I mean, she's just a great supporter of everything that we do, and her mind is just amazing. She has already created the plan of all. I mean, I'm looking at this other screen. You can't believe the stuff we're going to do in May. So, but I'm going to show you. Let me show you some of this stuff. So, and David, thank you, David. David always makes me look good. He edits these things to make me look good. James, hi. You're going to say you can't see the screen. I hope you're not going to say that. Let me see, PowerPoint slideshow. Let me see, David. Hang on, don't go anywhere, buddy. You're raising your hand. Can you see everything okay? If anybody's having trouble seeing anything, please let me know, because I need to know. You're good. Thank you, James. And thank you for being here. Welcome back. I'm glad you're here. So we're probably going to be talking about stuff, listen, I can't help it. I had 3 years of law school, 3 years of brainwashing, graduated first in my class in real estate transactions. I do a lot of trial work, probably more than I want to, but it's mostly to defend real estate brokers, but as an expert, not as a attorney. I don't practice as an attorney. I knew my last year there was no way I was going to practice. So if you're thinking about getting into law school, give me a holler. Maybe I'll talk you out of it, but I don't know. So anyway, that being said, let me go try to get this thing. I'm going to start cracking myself up. So I'm going to go to the next screen here. our conversation is not intended to be the substitute for the advice of your broker. I get so many, you're so wonderful. You send me emails and you ask me questions, and then you already say in the email, I know you're not going to get, I know I should be talking to my broker, but what do you think about this? And so, okay, fine, I'll do that. I'll have that conversation with you, but I'm not trying to take over their thing. They have to defend you, right? As does your attorney. So, that's, I can just tell you what happens in the industry, and sometimes it doesn't quite go the way that we would like it to go. So, our discussion today is live. I had a heck of a time yesterday, and I apologize for the people that were on Fast Stats. We had such a great webinar on the market, how to get the market condition, how to get the market information, all the statistics and the charts and graphs and everything. And then I couldn't find out how to get back to the, how to go back and look at past webinars. So here you are. I just was having a mental block. It was a long day. So SDR.com, hover over education, drop down to webinars. And then you can look at past, future, you can sign up for webinars. And that's what's really cool. But if you have trouble finding it, will you please send me an email. I will forward you the link, okay? And because I want you to be able to get to this stuff. You're in the live version today. It's Wednesday, 1 o'clock on a beautiful San Diego day. Ask me questions. Hit me with the Q&A down at the bottom. Hit me with the chat. I will answer them as I see them. They don't pop up on the screen. That's just kind of the way Zoom is. It doesn't show you them on the screen. I have to go down and look periodically. So I'll look at the end of a sentence or whatever, when I'm proselytizing about something. So, okay. So, here's what's coming up. Okay. So every Tuesday we have Paragon. Starts at 10 o'clock, although I now have to change this slide because now we're going to start this, darn it. Looks like I'm gonna have to do this elsewhere. 11:30 to 12:30. So it's going to be kind of a lunch Paragon, and we always do two of these a day on Tuesdays. Tuesdays are MLS day, so I'll be teaching a lot of classes coming up on the MLS, and so. And they're all live. Okay, so God, we cover some great stuff. I mean, they're probably among my favorites. So every Wednesday we do the RLA, we do the BRE. I've already discussed what that looks like. Today is the last day of our BRE, and then next week we're supposed to start the RLA, but instead I'm going to be doing the class. What am I doing my class on next week? Oh, new forms. Oh God, don't miss that. Okay, so all the new forms, and there's a bundle of them. So I'm gonna make it simple. I only get an hour to do it. I probably spent 5 hours on it because they keep changing the COVID-19 forms. But so I'm gonna try to simplify the process to make it easy for you. And then if you have a template that you're using, understand that we're gonna upgrade your template with those forms that are gonna come out at the end of May. So anyway, next Wednesday, new forms at 1 o'clock. Okay, RPA every Thursday. You all know one of my favorite subjects. I really think the RPA, that's where you get paid, and I want to see you paid. Okay, lawsuit avoidance, we're going to start that first Wednesday. Okay, so on the first Wednesday, 10 o'clock to 11 o'clock in the morning, we're going to be doing the RPA. I personally think we should do it every week. I could keep you spellbound on the things I see in court and all that, and so please don't miss that one. That one's going to be good. 10 o'clock, 10 a.m. to 11 a.m. on Wednesday. It is not enough time, but we'll have some fun, and I'm going to be looking for your interaction. Okay, zip forms, we do that the first Thursday of every month. And again, 10 to 11 a.m. Okay, so we just knock it out. It's just great. Okay, so thank you for joining us today. We're going to talk about the BRE. If you have any subjects you want us to talk about, would you please send them? I'm filling my Tuesday, Wednesday, Thursday. Okay, honestly, I just want my entire day. My devotion to the association is going to be on Tuesday, Wednesday, Thursday. So please send me whatever you think is a good one. Send it to education@sdar.com. The wonderful people there will take such great care of you. And then email updates. So once a week on Saturday night now, we send out a newsletter, email. Here's what's going on. Here's what's going on in the county, the state, the nation. Here's how your real estate market is going to be impacted. People ask me all the time, they say, what's going to happen in the real estate market with this COVID-19? I've got agents that have buyers that are, just out there going, oh, I can't wait. Prices are going to drop by 20%. Let me tell you how long I waited for prices to drop by 20%. I've been doing this 40 years. Okay. They're not going to drop 20%. And what happens in the rest of the world and the rest of the country is not San Diego. You live in the most beautiful place in the world. So you'll get an update. Okay. So if you want to be on that list, send me an email. I don't put you on there unless you send me an email that says, put me on the list. And I apologize. Yesterday, I had a whole bunch of people sending me emails. Sometimes it takes me about 24 hours to get everything updated, but I will send you an email that will say, I got you on the list. Thank you so much. Really appreciate it. Anytime you want to come off the list, just let me know. I mean, we have an unsubscribe button, but I've never had anybody unsubscribe. And when I was running the pitch session there in Del Mar, I had 2,400 people on it. Nobody ever unsubscribed. There's always good stuff. So please send me an email, kevin@burkerealestateconsultants.com. And then it's going to be somebody telling me to stop it. Is stuff covered in live, similar to that on the recorded webinars, current news withstanding. So here's what's going to happen, James. So the stuff that I cover live, I can answer your questions like I'm doing right now, right? We can have feedback. We can talk to each other. What they see on the webinar is the same thing, but they can't ask questions. So yeah, so like for example, if you had right now, you had a question about, well, how did Kevin handle the paragraph about commissions? Paragraph number 3, how did he handle that? That was one of our best webinars ever. So just go back into SDR's website, click on education, drop down to webinars, look at past webinars, and take a look at that paragraph number 3, because we killed it. Listen, we're at the last BRE session right now. And by this point, you have to be convinced that you will never work with a client again unless you have a contract with them, buyer or seller. Okay. And the BRE just kind of doesn't answer the question about how come it's the law requires you to have a contract in order to be able to say that you're their agent. And then when we ask the BRE, what do you think about that? They go, well, yeah, okay. So whenever they go, yeah, that means they're investigating people already. Okay, so I broke the news to you about teams, how they were coming after teams, and how they were doing that. And it's big right now. If you are renewing your license and you go in to renew it, you will see there's a question on it on the license renewal. Did you during the last licensing period, did you participate on a team? They are investigating teams. That doesn't mean it's a bad thing. It just means that some of the things that teams are doing are not necessarily the right way to do things. So for example, a question came up about the agent on a team. The agent on the team goes, was really the one that produced the transaction, and they do the avid. They go out and they do their agent's visual inspection disclosure. They come back and rather than signing the avid, the team lead signs the avid. Well, the DRE says that's fraud because you didn't actually go out and do the avid yourself. So you should have had the person that actually did the avid sign the avid. Okay. And we have that in our office where we have, for example, we have a broker that's in San Francisco, does a transaction in San Diego, Chula Vista, frankly, does a transaction in Chula Vista. We have another one of our brokers go to the property and do the avid, and that broker signs the avid because they're signing it on behalf of the brokerage. Okay. So little stuff, this is all coming out of your risk management committee at SDR. Let me tell you, it's lights on with this group. These are bright attorneys, big brokers. Okay, some of you are working for those brokers right now, and so here I am sharing that information with you. Okay, so James, thank you. Great question. Short question, long answer. But again, go to the education website and just knock it out because there's some really good stuff in there. And you'll have specific things, like I mentioned it yesterday on the purchase agreement, the liquidated damages, paragraph number 21. Go in, you can look it up. 21 was a whole hour and a half, and it wasn't enough time, right? And so I cover this in my law class when I'm teaching attorneys continuing education, real property law. We talk about liquidated damages. We talk about, of course, as lawyers, we don't want liquidated damages. As lawyers, we want actual damages, right? Because boy, we can get some real coin off of that. But it's not always in the best interest of the client to have that apply. So that's just That's just what it is. Okay. All right, James, thank you again. I'm sorry. I really got going. So thank you all. Sign up, boom. I'll hit you with this stuff once a week. That's it. James, question? I'll hit, oh boy, look at everybody showing up. Oh my goodness. Hey, George, welcome back, George. Linda's there. Mike, Monica Baker, Rhea, Robert, Renisha. Okay, good. I feel like I'm in Romper Room. Y'all know I was actually a child star in Romper Room back in the 50s, so 40s. God, when was it? Anyway, James, new app, and keep clicking on wrong button. Oh, good. You're doing good, James. Keep them coming, man. You're helping me out quite a bit. I really appreciate it. Okay, so let's go ahead and let me see if I can get out of this screen. Okay, good. We're gonna get out of the screen. So we pause the screen sharing for a second. You all got to look at me again. Let's get into our topic. Let's start talking. This one starts with paragraph 11, so we're going to go ahead and do that. Okay, today we're going to talk about dispute resolution. Hey, the fact of the matter is that sometimes we just don't get along. Okay, so now we're talking about the buyer representation agreement. So that's going to be, there's going to be some differences here, but dispute resolution, for all intents and purposes, if we don't have one, if we don't have a provision for a dispute, how to handle a dispute when it comes up, then we're just, we're all going to court, and there's no other way around it. Okay, so how do we handle that in our world where we don't want things to get out of control? Okay, I had a trial I was involved in. It was 3 years before we got to court, and I can tell you, we killed it. I mean, it was, I was the expert. I was the closer. I was the Trevor Hoffman of the transaction, of the lawsuit. And I got to tell you something. Everybody wishes it had never happened, but it did. And so it's, God, it was expensive, and I know, because I charged a lot of money for that. So, so let's talk about dispute resolution. Let's talk about the first of our provisions, which is going to be our mediation. Okay, so so why do we have mediation? Now I'm looking for my annotation. There's my annotation, because I love to write on these things. Okay, so let's talk about mediation. So what are my 3 levels in most of my dispute resolution? And by the way, online dispute resolution is coming. I'm actually going to be hopefully involved in the class that we're doing at UCSD on that. But because a lot of things are having to change, right, about the way we do business. So we're going to have like 3 levels. We're going to have a mediation. We're going to have, and then we're going to have either an arbitration or we're going to have trial. So it's going to really depend on what everybody wants to do. But remember, the default that everybody's agreeing to by virtue of the agreement between the parties in the California Association of Realtors level, all of our dispute resolution, I can speak, right? Dispute resolution begins with the principle of mediation. Okay, so mediation, you will notice there's nowhere to initial, there's no checkbox, there's no nothing. The default is mediation, and here's the challenge to that. Mediation can be as simple as everybody, you've agreed to mediate by default, and I've had this happen where it was as simple as going to the mediator. Everybody shows up at the mediator's office. Everybody gives the mediator a check for $250 or whatever it is, both sides, both parties, for $250, and then we see what happens. Okay, I've been involved in them where they went really, really well. The mediator goes from room to room, comes back and forth, trying to work everything out. After sitting with everybody in the main room and getting the gist of the case. Listen, I want to encourage mediation, because a lot of times we can get rid of it here. And even if you go, like I was in a trial in Los Angeles County, Orange County a couple of weeks ago. And the first thing the judge said, okay, you're all going to go out of the courtroom. This is the very beginning of trial, right? We're there for small claims. And the judge says, you're all going to go outside and you're all going to talk to mediators. And frankly, the judge is hoping that it's going to be over at that point. And some people will fix it out there, and other people will, and a lot of times it's just because, the mediator's trained to keep everybody talking nice rather than, yelling, screaming, and anger and all that kind of stuff, kind of like the political circus, right? So, so the way it's going to be is, we're going to agree to mediate first. Okay. So buyer and broker agree. So now remember, this is the buyer representation agreement. So the buyer and the broker agree to mediate any dispute or claim arising between them regarding the obligation to pay commission under this agreement, because that's what this agreement in terms of where our disputes come from, all of our stuff involves commission. Either the buyer refuses to pay the agent, or the buyer goes off and buys a house on their own someplace without their agent, and listen, this is here to protect you, okay? Or the agent doesn't do their job. That's the other side of this. The agent doesn't perform per the agreement, per the contract, okay? And we covered that when we were discussing, paragraph 5 and 6, the agent's duties, okay? All right, so before resorting to arbitration or court action. Now, I'm going to tell you, if you, you know what, I'll tell you in a second because it's going to say it anyway, but this is before going to arbitration or court action lawsuit, okay? So remember my other 2 options. So I want to start with mediation first, and then and then if that doesn't work out, then we're going to go big time, and we're going to go large, as we say in the legal system. It's going to get expensive, okay? All right, so mediation fees, if any, shall be divided equally among the parties. That's why I said a minute ago, each side gives $250, whatever the mediator is charging. Some mediators charge different. There's no set fee, okay? All right. Okay, so sorry, that's my tea, my afternoon tea. Among the parties involved. Whoops, let me get rid of my doodle here. Okay, so if for any dispute or claim to which this paragraph applies, okay, commissions, right? Any party, 1, commences an action without first attempting to resolve the matter through mediation, or 2, okay, before commencement of an action refuses to mediate after a request has been made, then that party shall not be entitled to recover attorney's fees. So win or lose. All right. So even if they would otherwise be available to that party in any such action. So here's the downside, and you need to know this, and this is how these clauses work. So the way what it says is, if you are compelled to mediate, which you are by contract, and you don't do it, okay? So for example, and we had this case. I mean, it was a great case where the party said, "Nah, heck with you. We're just going to sue you and go to court. We're not going to mediate." And then the court said, okay, that's fine, not a problem. But if successful, then you still have to pay their attorney's fees. So, so there's a huge incentive to at least show up for the mediation first. And as I said before, it may be as simple as just getting in there. I was involved in one where the mediator said, "Are we going to be able to work something out?" And everybody said no. That was it. Right? I think that one was 15 minutes. Yeah, out everybody goes. Okay. So be aware that if you attempt to do this, or commence an action when a request has been made, then that party is not going to get their attorney's fees, okay? So you're going to end up I misspoke a second ago, you're going to have to end up paying your own fees. So in other words, even if you win, you lose because you're going to pay for your own attorney, okay? Big deal, all right? Okay, all right. Exclusions from the mediation agreement are specified in paragraph 11B. So this is paragraph 11A applies to all cases. Let's take a look at what the exceptions are going to be, all right? Okay, so here's the exceptions to my mediation. So the mediation terms, this is B, following matters are excluded from mediation. So judicial or non-judicial foreclosure. So in California, we don't really have foreclosures. We have these trustee sales. Okay, so we have essentially what's referred to as a non-judicial foreclosure. A judicial foreclosure would be what the bank would have to go through in the event of if they had a mortgage. So remember, in a mortgage, you have 2 parties, a mortgagor and a mortgagee. In a deed of trust, you have 3 parties. You have trustor, trustee, beneficiary. Okay, and so in this case, no matter which one it is, all right, to enforce a deed of trust, mortgage, or installment land sales contract, which you are held to that as well, as defined in 2085, or an unlawful detainer action, or the filing of enforcement of a mechanics lien, and any matter that is within the jurisdiction of, and these are the big ones, okay? So anytime, and so just, if this is going to happen, check it off, it's gone. Probate, small claims, or bankruptcy court. So those are exceptions to mediation, okay? So you don't necessarily have to mediate. Those are exceptions. You could, if you're in those, first of all, if you're in a probate court, it's the law. I mean, it's the court. And so the court's going to say, hey, you don't have to mediate, bring it on. Now, they may give you the option of doing that, but like I said a second ago, even in that small claims action, the judge said, I want you all to go out and try to work out your stuff, and we've got trained mediators out there who are going to catch you, and hopefully help you get through all that. But there's no obligation to mediate. The judge even said it. You don't want to mediate? Come on back on in again. We'll go to court. Now, remember, in a mediation, you work things out. Supposedly you come to an agreement. The mediation is not binding on the parties, okay, unless they come to an agreement, and then the mediator will write down the agreement, and then everybody will sign that agreement, and now you sue on contract. Okay, so that's how that works. All right, so I love doing this little thing. I know it's probably not the most exciting thing for most people because they don't really want to think about the concept that they might end up there, but this is where it goes. So let's watch out for that. Okay, bankruptcy court, forget it. Let me tell you how bankruptcy court works. They don't care about any mediation. All right, okay, so it's Fed. It's not a state court. Okay. The filing of a court action to enable the recording of a notice of pending action. And what do we call that? We call that the lis pendens, okay, lawsuit pending. So the filing of an action for order of attachment, receivership, injunction, or other provisional remedies shall not constitute a waiver of the mediation provision. So if you file those things, you're just essentially tolling the statute, tolling the time period so that you don't lose your right to litigate, okay? Everybody good? Questions? Oh, okay. Hopefully you're all listening. I know you're listening because this is really good stuff, but that's okay. All right, so let's go forward. Let's take a look at 11C. Okay, now on 11C, we're going to talk down here. We're going to talk about, this is our advisory. So, and this is where did that language go that talked about arbitration? So I know we just saw mediation. Where did arbitration go? And the same thing, by the way. So in all of our listing agreements, so in the buyer representation agreement, remember it is a listing agreement. Okay, in the RLA, residential listing agreement, we decided at a point probably about 6-7 years ago to remove the arbitration provision because essentially our agents were binding our broker to an arbitration, to something that they didn't necessarily want to be bound by. Some brokers want to go to court. Now, frankly, I don't know. I have trouble with that. But if you want the arbitration provision to apply, let's take a look and see how that does. If everybody desires to resolve their disputes through arbitration now, so we had mediation, now we're going to have to make a decision, arbitration or litigation. Okay, they can document their agreement by signing the ARB form, which is my arbitration agreement form. So an exciting time for us now to take a look at that. And I used to, and this is another topic that I cover I've covered in our other webinars, that essentially, a lot of people just don't understand, and it's kind of a shame because it's really a neat topic. So let's take a look at our arbitration agreement. And again, some of you that have been around for a little while, Debbie, you've been in real estate for a long time, recognize this from the old listing agreements, from the old buyer representation agreements. So real simple document up at the top, arbitration of disputes, paragraph number 1, the parties agree, parties signing below, I'm sorry, let me go ahead, I'm going to create my marker again. So the parties signing below, okay, we're going to call them parties, agree that any dispute or claim in law, blah, 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 arising to them out of any of these agreements, you'll check the box, okay, or other, if I don't know what that would be, but all right, or any resulting transaction which is not settled through mediation shall be decided by neutral binding arbitration. So remember, no obligation for the parties to arbitrate unless you include this agreement signed by all the parties, okay? Now that doesn't mean, what it does mean is that, you go from mediation to litigation. But the parties can agree, instead of going straight to, going from mediation to litigation, the parties can agree now, or they can agree later. But if you do it now, then you have consensus now, rather than, you ended up, your client's this great big attorney who says, I don't like to arbitrate. I like to go to court. It's a fun place for me. It's like my sandbox, right? So that's what you avoid. And some brokers are going to take that position. So you definitely need to check with your broker. Do we like arbitration? And the broker might say, yeah, I don't know what happened to it. Frankly, that's what we did. We moved it out of the document because, some brokers were getting essentially blindsided later, finding out that they had to arbitrate their dispute. They didn't want to arbitrate. And now they were compelled to do it because their agent had that document signed. So remember, we bypass all that by the requirement, the DRE requirement that says that you have to get all paperwork, anything material to a transaction. So clearly anything signed by a party to your broker within 72 hours, unless your broker has a contract with you that says less time, like 24 hours. Like our contract says 24 hours because, we're writing the offers for our agents anyway, writing their listings. So we already know right away what it's going to say. Okay. So that being said, you have to get that to the broker. Remember, the broker's got 5 days, to come back and see. Remember, management approval. Broker has 5 days to come back and say, I'm not going to agree to this. But the sad truth of it is, a lot of times, we're not giving this paperwork to our broker until the day before closing. Hey, this one's closing tomorrow. I'd like to get paid. Here's the file. And we really need to watch that DRE requirement because we really need to protect our broker. So let's make sure, please, that we do that. Okay. All right. So parties also agree to arbitrate any disputes or claims with the broker, okay, who have not signed this agreement, but who in writing agree to that prior to or within a reasonable time after the dispute or claim is presented to the broker. So as I said, if they don't sign it at the beginning, then, and again, now it's compulsory, but if they don't sign it at the beginning, then, you could still get them to sign it later. So who's the arbitrator? Retired judge or justice, attorney with at least 5 years of transactional law experience, okay, unless the parties mutually agree to somebody different. So really those items above on who the arbitrator should be were really a suggestion, because here you've got, or unless you agree to somebody else. So that says, listen, we're just kind of giving you a suggestion of who that should be. And I have to agree. Do you want a real estate attorney? I was involved in a trial where the plaintiff hired an attorney who was a general practitioner, didn't have any real estate law experience, and they got creamed in court, right? Because the defendant, who was the broker, hired a real estate attorney, and a good one, by the way, probably one of the best I've known. Really good attorney. So there's some great attorneys out there. So hire somebody who's qualified. Okay. And that's essentially what this says. Okay. All right. So, the party shall have the right to discovery. All right. So remember, we tell you that, you might be giving up certain rights, and that's what we're going to see down here in the notice provision. So you might be giving, so here it says you have the right to discovery. So we have to say that so that you have that right. Otherwise you may not have that right. And that's what we're going to see down here. Okay. In all respects, arbitration shall be conducted in accordance with Title IX. Judgment upon the award of the arbitrator may be entered into the court having jurisdiction, which means you can take that award just like a court, just like you won in court. You can take that for purposes of enforcement. So here we go. Enforcement of this arbitration agreement shall be governed by the Federal Arbitration Act. Okay. And, interestingly enough, we have arbitrations at our association, at the San Diego Association, and then somebody will win, somebody will not win. And the sad truth of it is, in the mediation, everybody comes out a winner. You have some losses perhaps, but in a mediation, you're not flipping the coin. When you have an arbitrator or when you have a court of law, there's somebody there who's going to make a decision. The trier of fact is going to say, this is how it's going to be. You win, you lose. That's what a court does. That is what an arbitrator does. The mediator tries to get you all to work it out so it's a win-win, but in court, it's somebody's going to win, somebody's going to lose. Okay. And so guess what? We've had people come, we'll have the winner come in and say, that the defendant, the loser, whoever it was, whether it was the defendant or the plaintiff, the loser is not paying me, and I want you to help me go get it. We don't enforce that. We just don't. But the good news for you is it's even more powerful than that. You simply take the award and you take the award into court for enforcement. Okay. And then you've got all the other stuff available to you, garnishment, whatever, other things that you might have available. Okay. So let's take a look at our paragraph down here. Let's take a look at notice. This is the notice. Now, notice, it is in bold print, in capital letters, okay, in 10-point font. And the law says that when you create a document that has a provision where you have to have the statutory language in it, which this is, then it has to be in red if it's the same color. I'm sorry, if it's the same size font as the rest of the document. So the rest of this document is in 6-point font. And so since we don't know if you have a printer that prints in red, we have to have this in 10-point bold font. Okay, and that's just what the law says. So for a lot of us asking the question, why do we have to have that in 10-point bold? And the reason is because the law says that unless you have it in red, and since we don't know if you have a printer that prints in red, we're going to assume that you don't. Because we have to, otherwise you're going to be printing documents that are going to be inconsistent with the legal language, okay? So by initialing in the space below, you're agreeing to have any dispute arising out of the matters included in this decided by neutral arbitration, okay? Neutral arbitration as provided by California law, and you are giving up any rights you might possess to have the dispute litigated in court. So if you agree to this, then everybody's agreeing we're going to arbitrate. And guess what? The decision of the arbitrator is final, much like the decision of the court is final, and there is no appeal. Now there is an appeal, but usually it's only under an error of law. Good luck. Okay, it's a losing thing. I know people have had it happen, but it's like, why does lightning not strike twice in the same place? Because the place doesn't exist anymore. So in a court or jury trial, okay. I don't know. Some people have said to me, I've never seen a jury of my peers. I don't think any of those are like me at all. And so it's like, listen, I want to have, somebody, I want to work on an arbitration. It's cheaper. And you have your attorney there. You just get to a decision faster. And I used to say you get the same lousy decision, but you're there in 3 months rather than waiting 2 years. And by that time, boy, listen, I charge billable hours too, but wow, that can be a lot of money. So by initialing the space below, you giving up your judicial rights to discovery and appeal. That's why we had to include it up here, remember? Okay. Unless those rights are specifically included in the arbitration of disputes provision, okay? So that's why it said right up here that it is included, all right? Because this is the statutory language, and the statutory language says, unless it says it in the rest of it, then you lose your right to do that, okay? And your right to appeal, by the way, and I've talked a little bit about that already. I don't think we're going to cover that again. Unless those rights are specifically included, okay, if you refuse to submit to arbitration after signing this agreement, you may be compelled to arbitrate under authority of the California Code of Civil Procedure. We call that Civ Pro in the law field. It's a year law school. Don't go there. You go to law school if you want to go to law school, but boy, we couldn't even possibly touch that here. Figure out, Code of Civil Procedure. So this agreement, and this is important, your agreement to this arbitration provision is voluntary. You do not have to do it. So just remember, that's when we come up with that little rule that says that you must initial in order to have it, but you don't have to initial it. Okay, so if you choose not to initial it, and the sad truth is most agents are trained that they should always have the client initial it. Why? Because there's a place to initial it. That doesn't make any sense. Okay, that's like telling your client that they should initial liquidated damages when, you know what, frankly, it might not have been in their best interest, right? In an increasing market, they might be giving up money. So, and then you told them that they had to do that, okay? Sorry, I've got too many telephones. So anyway, I don't answer them anyway. So, okay, so we have read and understand the foregoing and agree to submit disputes arising out of the matters included in the arbitration of disputes provision to neutral arbitration, and this is where the parties would sign it. So this is where the seller signs it. Buyer signs it, because this is our buyer representation agreement, and this is where the agent signs on behalf of the broker. So remember, again, you are signing as the agent for the broker. You are signing as the agent for the broker, and so please make sure you get this document to your broker within the time period that you have to do that, so your broker can decide whether they want that to happen or not. Or better yet, have a conversation with your broker up front. Say, hey, do we like arbitration? Do we want that included in our listing agreements? Or either whether it's our seller listing or our buyer listing agreement, ask your broker. So remember, later on, when we get into the offer, we're going to see that the contract states that if if there's a place in the document for a separate initial, and that'll be my liquidated damages and my arbitration, then all parties must initial, and if or not, and if one party initials and the other does not, then we need to resolve that in the counter offer, okay? And we're gonna have a whole class, I'm hoping it was up on my screen, but we're gonna have a whole class on how to handle counter offers, how to do multiple counter offers, and that and such as that. Okay, so a real cool subject. I love talking about counter offers, but you know, I'm challenged sometimes to see them done right. So okay, I get it. All right, okay. So let's finish off this document here while it's still daylight. Now we're going to talk about additional arbitration provisions. So let me grab my annotator again. So what's my exclusion to arbitration now? So different exclusion, you're going to see it's the same as the exclusion to mediation. Okay, so following matters are excluded from arbitration: one, judicial and non-judicial foreclosure or other action or proceeding to enforce a deed of trust, mortgage, or installment land sale. Okay, so that's not going to apply. Unlawful detainer, that's going to be my rental or getting somebody out of a property. So, you know, where you let the, well, I'm not going to get into examples. And any matter that is within the jurisdiction of a probate, small claims, or bankruptcy court. So copy, paste, same language, okay? Same language in the arbitration as there was in the mediation provision. Okay, preservation of actions. So the following shall not constitute a waiver or violation. And again, we're right back to our filing of a court action to preserve a statute of limitations. Probably better defined here in the arbitration agreement than we saw in the mediation agreement. So in other words, I want to stop my SOL. I want to stop the statute from tolling, and so I might have to file that lis pendens. To do that, that is not going to be considered a violation of this paragraph. The filing of a court, sorry, that's the next paragraph. Filing of a pending court action, notice of attachment, receivership, injunction, or other provisional remedy, okay, or finally the filing of a mechanics lien, okay. So those are going to be additional provisions. And then finally, the brokers. Brokers who have not signed this arbitration agreement shall not be obligated or compelled. Remember that when you have your purchase agreement and the parties either agree or not to the arbitration provision there, that does not compel the brokers to also arbitrate. My non-legal advice is that I think that if the parties are arbitrating between them, the broker probably wants to have a seat at the table, only because first thing that happens is they throw the broker under the bus. So please, if you're a salesperson working for a broker and you get a notice of something that's going on, tell your broker right away. It's really important, because remember what I said, we love our broker. We want our broker to succeed, all right? We're not just, hanging our license there because, we want to make sure that they are okay. So anytime an attorney contacts you about a matter involving a real estate transaction, please let your broker know right away, okay? So any broker participating in arbitration but who have not signed this agreement shall not be deemed to be a party to the arbitration agreement, okay? So in other words, if the buyer initials it and then the broker does not, then that means the broker's not involved in it, okay? All right, so everybody good? Okay, and then down here we have the place for everybody to sign. This is a simple one-page document, but as you can see, it's pretty powerful. And the differences between who's going to make the decision in a dispute, if you couldn't work it out in mediation, do you want to have an arbitrator do it, which is why we talked about the qualifications of the arbitrator, okay, right here, retired judge or justice, okay? But there's some great like San Diego Association has a REMC, which is the risk management, the mediation center. There are a lot of people that look at that and go, wow, we're jealous, okay? San Diego's risk management department is just amazing, and their mediation center is awesome. State of California, they have their own, California Association of Realtors has their own. Frankly, I like ours. I know the attorneys there. We've got some really amazingly bright attorneys on that panel. Okay, so that's my arbitration of arbitration agreement or arbitration of disputes agreement. Okay, everybody good? I'm going to hope you all were able to see that document. Yes, you were. Okay, good. So let's take me back now. We're going to go back to our paragraph 11C, and that covered the issue of the arbitration agreement. Any questions? I'm sorry, I haven't looked down here Looks like we're good. Okay. All right. So now let's take a look at, this is what we call the signature block. Now, for those of you who have been reading along, you're going to see there's a lot of stuff missing from this, aren't you? Okay. So the first thing I see missing is my RCSD, or, my representative capacity signature disclosure in the event that one of the parties is signing on behalf of a non-natural person, right? So a natural person signing on behalf of a non-natural person. So the buyer could be buying the property in trust. They could be a buyer of a corporate, they could be a corporate buyer. They could be a lot of things. So that is missing from here. I would still use the form, even though it's not referenced here, okay? It'll come out in the new revisions, but it's not in this one, okay? And then the other thing that's missing is my additional signature addendum, which is something else that I like to see in these documents, okay? All right, so pretty simply, this is the place for the buyer to sign. The assumption here is that you only have two. The real estate broker. I had somebody ask me once whether or not it was enforceable against the parties if you didn't have their address or their phone number. Remember, the purpose behind that is for service of process, and also to differentiate that person from another person, maybe of the same name. And so, it's a good idea to do those things, but it also talks about, how do I contact you? So email, whatever, how do I get a hold of you? Okay. So, we want to make sure we're clear about that. And then the brokerage firm, there's no hiding you, right? We have the DRE license number for the brokerage. We have your DRE license number. Something else missing is, in some of our agreements now, we have multiple agents involved in it. I'm personally not a big fan of that. I think we should, there has to be one principal agent, and then you can have an additional signature or a additional agent acknowledgement form. And then once again, filling in the blanks. Okay, everybody good with that? We're doing really good on time, but we're not done. We do have a couple of other things. So nothing else on that page. So I'm going to go ahead and flip us over to some more exciting stuff. We talked about the arbitration. Where is my, I am missing a document. Where is it? Here we go. Okay, here's my buyer's inspection advisory. There's something else missing. I don't know where it is. Okay, so here's my buyer's inspection advisory. So let's talk about this really fast. Nobody ever talks about it, right? It's one of those things that, if it wasn't attached to the electronic version, you probably wouldn't even have your client sign it. We saw that happening a lot, with agency disclosures. If we didn't attach it to the document for you, then it just wasn't going to get signed. So this is attached to the document, but if you're printing them and you don't include it, woe unto you. This is a big deal, okay? Barry's tea, wonderful stuff. Okay, so let's talk. All right, so buyer's inspection advisory. Listen, do you need to be telling your buyer that they have an obligation to inspect the property? Yes, okay. I was involved in, I hate to keep bringing up court cases, but I was involved in a case where the buyer's defense was, well, I didn't know. I thought when the agent told me stuff that sufficed for my inspections. I didn't need to inspect it because the agent said these things. Now, frankly, the agent shouldn't be saying those things anyway, right? And that's why I tell you to read these documents. So especially this buyer's inspection advisory. So you want to make sure that you don't say something that is inconsistent with something that you've told your buyer to sign. And I need to sink that home. You've got instructions. Your buyer is getting written instructions written out by the lawyers, and then we come along and we say something completely different because we're looking for something to say or it's something cool. Okay, we think, wow, somebody said that to me in a transaction once, and I thought it was so cool that it just kind of stuck, and so now I'm saying it too. It must have been right because somebody else said it. That's not true, okay? All you gotta do is watch the news and you'll know how that works, okay? So let's take a look. Intentionally left blank, thank God we finally fixed that because we were making it a requirement that even though in the buyer's agreement, you don't necessarily have a property address, right? So for the BIA, for the buyer representation agreement, it is intentionally left blank, and that language is actually right on there. Okay, what is the importance of doing property investigation? Listen, you and I know, and I had one property that I have ever bought in my 41 years of real estate. I bought a property without having it inspected. I'm going to tell you because I was Mr. Smart Guy, and this was actually right before law school. And I'm going to tell you, I'll never do that again. So we absolutely need to have the buyer inspect the property. We need to let the buyer know that it is important to investigate. And now you've heard me say before, our form is called an inspection, but we tell them that they need to do an investigation. So remember, the standard of care for the buyer is that they have that duty to investigate. Your duty is one to inspect, a reasonably competent, diligent, visual inspection of the premises, but we want the buyer investigating. We want the buyer to dig and poke. Those are duties you don't have, okay? Physical condition of the land improvements being purchased is not guaranteed, okay? Boy, they always come back up like you're the warrantor of the product, right? Things that, something goes wrong, when are you gonna find out that something was wrong? It's always after close of escrow. So please don't make any representations. I know this is a beautiful home. Oh, you'll live here forever. That doesn't mean anything other than I can personally guarantee you that the construction of this property is flawless. I wouldn't say that, but I've had people do it. So please don't do that. You are not the warrantor of the product. You are not going to guarantee the condition of the premises, okay? You, the buyer, you have an affirmative duty, which means you, the buyer, need to go in, exercise reasonable care to protect yourself, include discovery of the legal, practical, and technical implications of disclosed facts. So in other words, whatever we tell the buyer, that they have to investigate that further, not you, not the seller. So the buyer has that obligation. I'm emphasizing this because I have so many times where the buyer will come back and require the seller to do further investigation on their property. No, their duty is limited to disclosing what they knew or should have known. That is the standard of care for the seller in the state of California, okay? The buyer's duty now is to investigate deeper whatever those disclosures were. Now, seller gets in trouble if they don't disclose things, but they don't have to over disclose. And this is why I have argument with, we have it in the listing agreement now that the broker, with permission of the seller, can order reports at the time of the listing. I totally disagree with that. And I go head to head with attorneys all the time. I got half the attorneys on my side. I got half the attorneys that are saying no. You know what? The seller doesn't have a duty to investigate their own property. They don't know something, they don't know it. And so by doing further, having the seller investigate the property, a lot of times you're going to preclude the buyer from doing it. And I think that's the dangerous part. So the seller has a termite inspection, or pest inspection, there's no termite, pest inspection done. And then the buyer relies on that report. And then of course, later on, they find termites or wood destroying, organisms or whatever. And now there's a lawsuit, and it's like, well, you gave us the report. We assumed you knew, you ordered it from a credible agency. Don't get into that, okay? Let them do that. They have an affirmative duty, okay? And the investigation and verification of information and facts that you know or that are within your diligent attention and observation. So that is aside from the seller's duty of disclosure. So remember, seller's duty attaches by virtue of Civil Code 1102.3. Your inspection is attached by virtue of Civil Code 2079. So you have an obligation by law to inspect the property, not to investigate it. And this is why I like your inspection happening earlier, your agent inspection done earlier in the transaction, because if you do it later, then a lot of times the buyer, if they're trying to wiggle out of a deal, thinks that adds to their ability to rescind the contract, that it reinstates the rescission rights, even though the seller made their TDS disclosure at the beginning of the transaction. So please don't wait until the end of a transaction to do it. Please do it in the very beginning. And I talk to my agents all the time about this. It's like, where's my Avid? I need to have that from you. I need to have it now, not 2 days before closing, because then the buyer's looking for some way to get out of the deal, and that's not a way to get out of the deal, but they think it is, and so then we're going to be litigating that. So a general physical inspection typically does not cover all aspects of the property, nor items affecting the property that are not physically located on the property. And so here's the thing, as agents, we tend to get into the habit of telling buyers to just have a physical inspection. Listen, folks, if I give you no other advice, the buyer's election of inspections form that SDAR has is going to trump everything. I love that form. We wrote it for the longest time. CAR wouldn't put it in the library. It's in the library now in your Zip Forms program, but it's under San Diego Risk Management forms. And if you aren't seeing those forms, you need to let us know. Get a hold of our membership department, 858-715-8040, and get that loaded into your Zip Forms program. You're paying for it. You're a member of SDAR, so that you get that library for free. Buyer's election of inspections, excellent form. It's pages long. It tells the buyer you have the right. You can do all these inspections, and this is not an all-inclusive list. But when you're getting a list of 5 pages of inspections that are available to you, it beats the heck out of you should just have a physical inspection done of the property. I think that is wholly lacking in advice, and I think you need to make sure that you're doing that. Okay. Do you go through the inspection report with your buyer? Absolutely, I do. So I do go through the inspection report with my buyer, but I don't want to be the warrantor of it. And I have to be careful that I'm not there. Remember, your duty is to disclose. So Rhea, write this down. Disclose, not diagnose. You are not there to take the place of an inspector, okay? So I always tell you, when you have your physical inspection done and then you're going in there, you're gonna do your agent's visual at the same time, the inspector goes left, you go right, okay? So you don't wanna, you don't want anybody thinking that your inspection of the property is a substitute for the investigation done by the buyer's inspector, okay? So yes, so the answer is, do I go over with them? Sure. What kind of questions do you have? And if you do, I'm going to probably refer you to the inspector. Why don't you contact them? They have their own separate E&O insurance to cover their actions and cover what they tell you. But yeah, I go over with the buyer. I mean, I'm really, I can't even remember if I've ever had a buyer want to go line by line. If they want to get to that level, they need to be talking to the person that did the inspection. I didn't do the inspection. I'm not there to, I'm not qualified. I don't, listen, I am not a contractor. Okay. All right. So I'm not there to second guess the opinion of the inspector. You should call the inspector. All of the inspectors that are out there are fairly good. Make sure they're CREA certified, ASHI certified. We have one in particular we love to use. I'll tell you offline. But at the end of the day, listen, they need to be doing their own, and they need to be communicating with the person that they hired to do that. Okay. So it doesn't cover all aspects of property, nor items not physically located. If the professionals recommend further investigations, including a recommendation by a pest control operator. Here we go with our pest control operator again, to inspect inaccessible areas of property, you should contact qualified experts. Remember, this is your statement. This is your statement to the buyer. This is your get out of jail free card. Okay, that's how important that is. Saw a question pop up there. Great idea to ask the buyer to talk to you. Absolutely. Listen, oh my God. Now, I don't know. So I've done a couple transactions in my career, right? I'm doing at least 100 a year transactions, all right? I'm talking to you because I want you to know this, all right? And I can tell you, always after close of escrow, the buyer calls me up on the phone and says, how come you didn't tell me about this? I don't know anything what you're talking about, because that's not what I do. So, and they're always going to try to hold you accountable. So listen, you need to refer them to qualified experts. So again, I mentioned this in another class, that we do have an approved vendor list. It is vetted. These are people I work with. I have people frequently asking me for a copy of it. More than happy to provide it to you. At the top of the queue are a whole bunch of attorneys, most of them real estate specific, really good attorneys. And listen, I know them well. And not just because I get paid, a lot of them, they don't hire me to represent them, because most of the cases that I do depositions in end at the deposition anyway. Go figure, right? So anyway, sorry, I went a little bit overboard on that question. When you represent, hi Debbie, when you represent the buyer, do you suggest your buyers order a pest control report themselves? Right out of the contract, paragraph 12. Or ask the seller to order. No, I don't ask the seller to pay for it. And here's why. The language is pre-printed in the RPA that says that the buyer has the right to do inspections, investigations of the property. pre-printed language. If we were to separate that, go back to the way that we used to do it, where we used to have a checkbox that says that the buyer is to, or that the buyer or seller, somebody is to have an inspection done, a pest inspection done, that's when the lenders would start triggering a requirement for clearance. And so the language is still in there. We've just put it in there so that it's not a separately checked box. Because when we created this version of the contract, after 40 years of doing this, we created this version of the contract so that now, we contacted the lenders. We said, how come you keep requiring clearance? We even took away, we even made it so that they don't have to do one. And they said, well, yeah, but you have a checkbox. So would you believe the checkbox caused the lenders to continue to require the clearance? So we just took out the checkbox. So now the buyer and the seller, buyer does a pest inspection on their own. That's their job. They're in charge of investigating the property. Why would you have the seller investigate their own property? It doesn't make any sense. So the buyer investigates the property, and then now the buyer can go and negotiate with the seller. A lot of times we found in our experience that the buyer was going to do remodels or do upgrades or something that was going to take out, I don't like those toilets. And then you make the seller go in and put in low-grade, low-flow toilets, and then the buyer just tears them all out anyway, right? So, why do you go through all that? So give the buyer and the seller the ability to negotiate repairs, which is the appropriate time to do that. Okay. So good question, Debbie. So yeah, we definitely want to make sure that everybody understands that the buyer has the right to investigate, and that includes, and we have a great big paragraph about that. Thank you, Debbie. Great big, and I know a rhetorical question because you and I have talked about this, so I knew you knew the answer already. But at the end of the day, I never have a seller pay to investigate their own property. I'm just not going to do it. Okay. Now, none of my sellers will ever do it. We just don't. Now, my sellers will pay for a natural hazard disclosure, right? 1103.7 Civil Code. Okay, they'll pay for that. But a lot of times, everybody's looking for somebody to pay for something. So on your purchase agreement, on paragraph 7A1, the only thing that I look for in 7A1 or 2 or 3 is the natural hazard disclosure, and that's because the disclosure is required by statute. A third party doing it is not. Okay, but clearly not a pest inspection. It's not going to show up in there. And I get offers that have it, and I counter it right out, and everybody goes, oh, okay. And so, buyer still has a right to investigate for pests, and then they can submit a request for repairs. We're not going to obligate the seller to doing work without knowing what that work is. And so that's just going to serve the purpose of blindsiding the seller, and we don't want to do that. Okay. So good question. Thank you, Debbie. I know you know the answer to that already. All right, I'm going to pin this down here so I get it out of the way so I can minimize my window. Okay, did I get everybody? Other questions? No, not yet. Okay. All right. So where am I? So you should contact qualified experts. So number 2, broker obligations. Let's talk about the broker. Brokers, now this is big. This is really big, okay? Brokers do not have expertise in all areas and therefore cannot advise you on many items, such as those listed below, the ones we're going to talk about in a second. If the broker gives you referrals to professionals, broker does not guarantee their performance. So this is the part where I tell you that, listen, don't say something that contradicts what is in the agreement. So the buyer is going to sign this. So now the buyer understands that you do not have expertise in those things, right? You do contracts, you do real estate transactional things, you don't do all these other things, okay? We're not going to guarantee their performance. Remember what I said before, I don't want to be the warrantor of the product. So don't say things or make representations that are going to call you out and make you responsible for it, inconsistent with what this document says. So that's why it's so good to read the document, because now at least you're going to know, exactly what am I committing to? What am I supposed to know? Those kinds of things, okay? All right, got the other question. Okay, good. All right, so you are strongly advised, and we're going to go a little faster here because this is just going to be homework for reading. You are strongly, this is you, the buyer, strongly advised to investigate the condition and suitability of all aspects of the property, including but not limited to the following. If you do not do so, you are acting against the advice of brokers. You see how important that is? Jackie Oliver, one of our attorneys on the risk management committee, she writes this stuff. She writes some of these things. I tell her, I said, Jackie, you make it sound like as if you don't want them to buy the house. And she says, no, what I do is I write a document so that if they buy this house, I'm going to hold that document up. If anything goes wrong, I'm going to hold that document up and says, I told you not to buy the house, even though, she does that in all of her stuff. So she's really good. Some of our attorneys, I mean, they just all have different spins on how they approach things, but it's always good, right? Okay. So general condition of the property, let's talk about that. And its components: foundation, roof, condition, age, leaks, useful life, plumbing, all these things, okay? I don't know. If you don't investigate these things, then you are acting against my advice. Don't you love that nice blanket coverage? Square footage, age boundaries. Please do not quote square footage, okay? Only time, excuse me, only time I want to see square footage is on in an MLS listing, because the MLS rules require it, okay? So, but guess what? Anywhere else you put that, I don't care what you put in. Square footage is the #1 litigated issue against brokers. And that Gov Hutchinson said that, okay? So it's not just me coming up with that, all right? The reason I asked about pest control, represent a seller, let's go on, the buyer asks the seller to provide one. Okay, I wouldn't. I'd counter it out. One of our brokers did it. One of our brokers agreed to it. And same thing. It's like, okay, and then we had to do damage control throughout the whole transaction. No infestations were noted on the report or by seller. The buyer repeatedly asked who selected the company and based on what criteria. Yeah, why do you do that? Okay, give them a thing. I mean, there's some really good pest control companies out there, but I can tell you, I've sat down with the owners of some of the biggest ones in San Diego, and knowing that we were getting rid of the WPA form out of the old purchase agreement, and knowing that their business was going to come to a halt, because all this time real estate agents have been trained that you have to have a pest inspection. You don't. Even on VA, you don't, okay? And so it's misnomers. But square footage, watch out. Don't do it, okay? All right. We don't verify. We don't know where the fences are. We don't know where the boundaries are. Don't be telling them that, when they say, well, how far does the property go? I had a good case on this. Well, it goes over there to that fence. It's like, probably not, right? Okay, all right. We're destroying pests. Here we go again, Debbie. Presence of or conditions leading to the presence of these things. If you don't have your own inspections done, so again, once again, I'm going to tell them that they need to do it. The buyer needs to do this, and it's also in the purchase agreement. It's all over the place. And so when they file a lawsuit against you and say that you said that they have to do it, you're going to come back. Here's your lawyer's going to look at this, and they're going to say, well, here's the purchase agreement says that we're telling you to do it. Here's the buyer's inspection advisory saying that you need to do it. And here it even says, if you don't do it, you're acting against our advice. Okay, so please don't make statements that are inconsistent with that, okay? You're telling them to do it. It's okay. They need to do it. The buyer needs to do it. Forget the seller doing it. You're just adding another chain to the loop of trouble, okay? Because and then everybody's going to say that you referred it. It's like, I didn't. I don't want to have anything conversation. How come I can get away with it all these years, right? So hopefully that helps. If you want to go deeper into it, check in with me offline, and we'll talk about it. But I just think it just creates all kinds of problems for us. And again, I like going to court, but it's not good for all of us. Okay. All right. Soil instability. I was at a house on Pacific in Solana Beach. Listen, those houses that are on oceanfront, I would definitely have a geological survey done. I would tell the buyer, you might want to have a geological survey done, because some of those places have underground caves and things like that. And so when the house collapses, because the cave collapsed, they run a soil core, and they find 10 feet of airspace in there, that's probably going to be a dangerous element. So definitely I would probably have those things done. Okay, but at the end of the day, existence of fill or compacted soil, expansive or contracted soil, susceptibility to slippage, settling, or movement, and the adequacy of drainage. If you don't check it, Mr. and Mrs. Buyer, if you don't have it checked, you are operating against the advice of the brokers. I love that. Okay, everybody good? All right, let's we're going to get moving forward here and wrap this up. I got one more page after this. Okay, so now I'm water and utilities. Okay, water and utilities, well systems. All right, we are updating in the new forms thing that I'm going to be doing next week. We are updating the SWPI. I think the SWPI, the Sewer Well Property Monument Disclosure Inspection Advisory, I think should go the way of the WPA. That's me personally, and I'll probably get into that when I talk about it. But components, waste disposal, all that stuff. If you don't have that stuff investigated, especially you're buying a property that's on septic, or you're buying a property that's on well water and you didn't have it investigated, okay, that's on you. Environmental hazards, I could go through the whole list. I have a graduate degree in hazardous materials management, so I could certainly talk about that subject all day. But if the buyer doesn't have that inspected, then that's on them. Okay, we want to make sure that we take the burden off of you. All right, earthquakes and flooding. Listen, I tell people all the time, we're an earthquake country, right? We know, Lynn and I watched 2012 again. We only got through half of it. I like the visual special effects and stuff like that, but wow, what a crazy movie. You don't think we live on an earthquake area? Yeah, we do. Okay. So, you certainly don't want your buyer coming along later on buying a property. They're moving here from Connecticut, which, by the way, has earthquakes. And so they're moving here from Connecticut and they're buying a property and they go, I didn't know it had earthquakes. And you're going to go, I'm sorry, I had you sign this document and I told you to investigate for that stuff and you chose not to do it. Okay. How about fire hazard and other insurance? I don't know. Okay. I don't know anything about those subjects. I am not going to be an expert on it. But everybody's going to agree that they need to do their own investigation of the property. Okay, so God, finally, how many are there left to go here? Okay, this is the second to last one. Sorry. So building permits, zoning, and governmental requirements. I don't know. Can I build a 2-story house? I don't know. 858-755-9313. What's that? That's the telephone number to Delmar Planning and Zoning. Call them, ask them. Be the source of the source, not the source. Follow me? Be the source of the source, not the source. You don't want to be a source. You want to refer to the source, and certainly you want to refer to a governmental agency if you can, because the truth will set you free, right? Okay, rental property restrictions, they change constantly, all right? And certainly something a lot of people don't know, deadbolt or other locks, those things are also codified. So 3/16-inch throws, things like that. So if you don't know what it is, good. You need to tell your buyer to investigate it. Don't purport to know something that you may not necessarily know. And again, once again, the rules change constantly. Don't get sucked into that, okay? All right, and then let's wrap this up. Security and safety. Laws require installation of barriers, access alarms, self-latching mechanisms, blah, 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 blah. You need to be investigating for that, okay? See, it's good to know what these things say. So now you know what the buyer was told. The time to read the contract is not in front of your lawyer, okay, or in front of your client. The time to read it is now. While you're homeschooling yourself, right? While you're at home, you need to be reading these things. What a great opportunity to increase your professionalism. And now you can say, God, I know that in the buyer's inspection advisory that it says right there that, the buyer should be investigating these things. And then if they buy stuff and then here you have the physical inspection and that's all they do, okay, you're operating against my advice. I think you should do all of these things. And I've documented the fact that I told you to do it. All right. Now I'm being emphatic about it, right? But I'm telling you, it should make you feel good about your job to know that you are not held to the standard of knowing what these things are. Remember, as a real estate licensee, you are held to the standard of the education required to get your license. And so the more you start getting into telling people things that are beyond that, the more trouble you're going to get yourself into. Okay. So please don't do that. All right. Okay, so I think that's a neighborhood area, subdivision conditions, personal factors. I always tell them, I say, listen, demographics, don't know what to tell you. I don't know about schools. I don't know about employment ratios. I don't know about crime, violence, things like that. I know they exist. I don't know how it affects this. I don't know about registered sex offenders. I don't know about any of these things. You need to investigate it yourself. So that's why our contract says you have an obligation as the buyer to go to Megan's Law, a database, to look that stuff up. I'm not going to go look it up for you. I tell the buyer, when do you sleep? They say, I sleep at night, like everybody else. And that's not true. Not everybody sleeps at night. Okay. So if you're worried about what the neighborhood is like, then maybe, because you're going to be spending most of your time at home at night, maybe you should go park out in the neighborhood someplace, without looking, suspicious. Park out there and take a look and wait and listen to what's going on. If you see cars pulling up in front of a house and they're clearly running a meth lab, maybe you want to live near it. Maybe you don't. I don't know, but that's personal to you. Okay. So that's why I love telling the buyer about these things. I love going through it. I'm not going to read them this when I'm sitting in front of my client, but from a practitioner's point of view, I want to make sure I have it in front of them, that they took the time to look at it. And I want to say, hey, you have any questions about security and safety? I mean, I can't really tell you anything, but you need to be checking for that stuff. You need to be checking for the neighborhood area. Can I paint my house green? Right? Subdivision conditions may say no. Okay. All right. We had a client bought a house next to a church. And they wanted to live next to the church so that they wouldn't have to fight for parking when they got to the church. And so then they killed the deal, midway through it, because they realized that cars parked in the parking lot at the church. And we're like, well, that's why you bought the house, was because you wanted to not have to fight the traffic. Then they realized there's noise from the cars. It's like, oh Lord. So, okay. So that being said, how's everybody doing? Any other questions about that? I mean, I've hit you with a lot of stuff. This has been I think a fairly good webinar. But what other questions do you have? Let me see if I've got anything else to share with you on the screen. Signature pages are covered arbitration agreements. What do I have? That's my screen. Okay, good. Okay, so question. Oops, sorry, I lost you there for a second. Thank you, James. Thank you. That's always nice. Thank you. I really appreciate it, folks. By the way, I got to tell you, I get some nice. Thanks, great idea to ask the buyer to talk to the inspector. That's a great idea. Talk to the inspector. Yeah, they got insurance for that stuff. I'll tell you something. All the years I've been doing real estate, I've had one time where I've had somebody go back against an inspector. Once. Now I know of lawsuits against inspectors, okay, and I can give you the list and what that looks like, and it's ugly. All right, make sure they're certified, okay, make sure they have credentials. Remember, the credentialing requirements for the building inspector is greater than the state would have. That's why the state hasn't jumped in and made them go through different requirements. But I can tell you, one time ever, I had a judge I was representing. He bought 4 properties from me, and the one he bought to live in, he didn't sue. He went to the inspector and he said, you didn't tell me that the kitchen sink was leaking, was dripping. It was such a stupid thing. And he was just he didn't like how much money he was paying for the inspection, right? He was buying a house. This was a La Costa for like $250,000, and he was worried about a sink, and so the faucet. And so the inspector says, you know what, I just get rid of this guy. I've done 4 inspections for him. He's just trying to get some money back. So he bought him a new faucet. I just thought, that's the only time I've ever had that happen. Hire qualified people. If you don't have a list of qualified people, let me know. I'll help you. I've got people out there that are really good. Go to the CREA website, CREIA, CREA.org, and look up inspectors in your area, and look for a master inspector. Those are the ones that teach the business of inspecting. Okay, so thank you, Monica. And I know I get carried away. Christy, thank you, sweetheart. I get carried away only because I think this business is so much fun. For me, it's all about the humor. I want you to have that same attitude, when you get, to be in this business 40 years from now, that you're having as much fun as I am, because I just think it's incredibly entertaining. My agents occasionally will ask me to go with them on listing appointments. And so I love going on listing appointments, right? Although, God, those are fun, right? I can't do them for other brokerages, but or sit down with a buyer consultation. We're going to be doing a whole class on, I'm in the middle of creating the new agent series, which you are going to love it. I mean, all about, we're going to have a whole session on the buyer consultation. We might have to have 2 or 3 on, how to talk to the buyer, ask them questions, take care of the problem before it becomes a problem. Okay. So deal with it up front, have everybody have their expectation level set up front, and then you won't have to deal with this again later. And if you're like me, I got a guy who's done 22 transactions with me, and I want that to be you too. Okay. So I want you to have the same kind of fun in real estate as I have had over these years, over these decades. And I clearly thank you all for being here. Let me pull up the slide here. I'm I always mess this up. Oh, well, first of all, I need you to be able to see it. Oh, there you go. Okay, you can see that. And then I'm going to do a slideshow from the current slide. If you have sent me an email, Monica, I left your thank you up there only because it really means a lot to me. I really do appreciate that. You, Christy. Oops, was there somebody else in there? Make sure I got everybody. If you have asked me to put you on the email blast this week, then give me a little bit of time to make sure. I always send you a response. It may not be the same day. We're in the middle of our CAR business meetings, and they're all virtual. And tonight I've got a caucus meeting that I'm running because I'm your regional chair for Region 24, which is San Diego. So I'll get it before I send them out this weekend, okay, for sure. But I want you to be able to get a hold of me. So here's my email address again. I got to figure out how to. I keep moving my own screen around. So how do I get that, Linda? Oh, here we go. Okay, so I'm going to go to presenter view. Come on, give me that. There we go. All right. So send me an email. If you ask me to put you on the list, if I have put you on the list, and like from last week, everyone for sure last week that asked, if you did not get the email, then that means, and fully a third of the emails are not going through. And part of that, it's coming out of Constant Contact. And part of the problem is if you have a free email, whether it's Gmail or AOL or Yahoo or Hotmail or all these things. I mean, I have some great friends that are on Hotmail, and it's like, we're just doomed, right? So if you are not getting the emails, it only goes out Saturday night. So if you just got signed up yesterday, I'm going to send you an email acknowledging your request. But then on Saturday night, boom, out goes the email. If you do not get that email, will you please let me know? People say, oh, I don't want to bother you. Listen, you're not bothering me. I'm here to help you. I keep asking, how can I help you? So obviously I want to hear from you, okay? So, okay, that being said, I'm not going to go any deeper into it. Send me an email. I hope you all are having a fantastic day today. I look forward to seeing you tomorrow. We're going to wrap up the RPA. We're going to handle the last paragraph of the RPA. It is clearly not the same as this one. We're going to talk about the broker box. We're going to talk about commissions, the duties to pay, time for acceptance, all that stuff. So thank you all for being here. I wish you the very best. And I look forward to hopefully seeing you again tomorrow. Take care for now.